What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are going to break down the hearing that was the Karen Read case about all sorts of alleged lawyer misconduct. It was a really important hearing. I thought a lot of people said it was a big waste of time. It was a nothing burger. I disagree. I think this hearing is going to be incredibly important. I think Judge Cannone has a big decision ahead of her. But regardless of what she does, this hearing is going to affect how this case is litigated and how the second trial is done by all of the lawyers involved. So we're going to break it down. We're going to watch together. And of course, I'm going to answer your questions. So please hit that like button. Let's get started. All right. So we have a lot to get to. We're going to jump right into it. I did want to say off the top that Judge Cannone's comments at the very beginning of this hearing, setting the stage for what is going to be argued, what she was thinking, why we stopped the last hearing, and why we came back here a second time. During the last hearing, I just kind of said they should have just let them argue it. That's what lawyers do. She found out some information, let them respond to that. But Mr. Alessi made a good point in his arguments that Brennan didn't brief this. Brennan didn't give them the information beforehand. Brennan didn't give them the documentation. Brennan didn't give them the affidavits and the exhibits that may have existed for the allegations that he was making, which makes it problematic and makes it difficult to be ready for something like that. I was under the impression they were ready for this hearing and that this hearing was going to be on what they were talking about. It turns out that was not true. And so Judge Cannone did the right thing in stopping that last hearing and pushing it until this week. So from my perspective, I think she did the right thing. Last video, I said she should have just let it ride and let these lawyers do what they do, and that's argue in court. I was wrong. I think she did the right thing. I think the defense agrees and felt like this was the right thing. I think the Commonwealth agreed. I think everybody agreed that this was the right thing after we had this hearing today, because a lot of prep and a lot of information needed to go into it. But kudos for her for setting the stage, which we're going to listen to now. So we know exactly what the point is of this hearing and why we delayed it to now and what's happened to now.
Previously undisclosed relationship, perhaps, between defense counsel and the ACCA witnesses. I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ACCA witnesses testified. There is another email that was 2 days before the trial, and after the voir dire, 2 days before the trial, with a list of cases. The Sunday before.
I also wanted to mention, because I see some people talking about her comments and her grave concerns. If I was going to put the betting odds, right? I like sports betting a little bit here and there, responsibly, of course. I expect to lose every time I bet. But when Brennan made the first comments about the feds gave us these documents, not the defense, that was so important. Well, I think when she heard that and she took her first break and she walked back there to review whatever she was going to review, I think the betting odds would have been she was going to remove Alan Jackson from the case. Then when I think she came back and she heard Brennan kind of correct himself and she was already planning on suspending the hearing, I think it was kind of a toss-up 50-50. And I think that's how she kind of came into this hearing, that depending on what I hear in this hearing is going to make the determination as to whether or not she's just going to boot Alan Jackson off of this case. And after we listen to everything, I'll give you my thoughts. I feel pretty confident I know what she's going to do at the end of the day. I could be wrong, right? I've been wrong before. But I'll give you my perspective on what I think she's going to do once we listen to what we're going to hear from this hearing, which is, of course, going to be clips. We're not going to listen to all 5.5 hours.
The witness testified. There's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ACCA witnesses were expecting to get paid.
So she gives us some additional information there, that it is not just travel expenses and costs, which it's funny. Some of the chatters and the people discussing it before were hammering me for saying that's a lot of money for travel. I don't care if it was 2 people, $23,900, whatever it was a lot for travel. Well, and in fact, it was not travel. A lot of that, and we're going to hear it in detail as they go through the invoice, a lot of that was trial prep, which makes sense. Now, she says they expected to be paid. If you remember all the way back to before the first hearing when my dad and I were discussing it, we said the same thing. Unless they just did this out of the kindness of their heart or the goodness of their heart or for publicity, which I would be shocked, they got paid. They expected to get paid. The question is, who did they expect to pay them? And when did they know who to expect to get payment from? Those are very important questions.
So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So
I will say, I try not to dive into the whole, like, that Judge Cannone is so against Karen Reed and whatever. I think she's prosecution leaning. I think lots of judges are. I think she leans even heavier than most judges, is way further leaning towards the prosecution and against Karen Reed for a lot of different issues. I don't think that she's like in it against Karen Reed, or if there is a conspiracy that she's in on it. I don't like, feeding into that at all. But I will say it was a little annoying how she said, well, I had to stop everything and do this other hearing because the Commonwealth raised issues with the court about the candor of the defense in discovery. And from that perspective, fine. If that's her MO and that's her process and that's what she wants to do, why has she never stopped everything and called an emergency hearing about the problems with the Commonwealth and the candor for the Commonwealth and how videos keep coming out and their witnesses clearly are not giving, at least, if I'm going to give the benefit, that I try to give the benefit of the doubt to everybody. Some people were saying on Twitter, I bet you don't give Hank the benefit of the doubt. It's like, yeah, you obviously don't watch, because I give him plenty of the benefit of the doubts. I give everybody as many benefits of the doubt as I possibly can. But when we start to find out that Higgins was actually on the phone at the police station and all this information that the defense brings up, that they can't trust the Commonwealth, at least the last Commonwealth team, for how they've dealt with discovery. I never remember her saying, we got to stop everything because one of the lawyers has brought up a concern with candor of the court. So it doesn't really feel like her MO, yet this is where we are here.
It made sense to me to suspend, first and foremost, for that reason. So counsel can be prepared to make any comments if you choose to. Second reason is, what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at sidebar on February.
So here is the biggest issue. Okay. This is another thing we didn't know. And there's going to be things I say in this video that both sides, whatever side you're on, you're probably not going to like. Okay. Let's just get through that and get past that, because I want to be able to have a conversation with you guys as the chat, people that think she's guilty, people that think she's innocent, that think the conspiracy is absolutely true, and people that think she absolutely did this and is trying to get away with it, building the narrative. If that's what you believe, that's fine. Let's have a conversation about it. That's really what I want to do. And I also know what it is like to be a lawyer and try these cases. It is not always cut and dry. It's not always easy. It's not always black and white. Alessi says later, this is hard. It's hard to be a lawyer. I say that all the time. It's hard to be a trial lawyer and to try cases like this. It's hard to be a judge sitting in her seat, right? And there are some things I think that each side said, that each lawyer said, that I'm going to say, not as big of a deal as it may seem, okay? And this type of stuff happens a lot in trials. There are going to be other things that are problematic, and we've got to deal with them. And 2 of the biggest things are the invoice with ARCA and this sidebar conversation that with Alan Jackson that happened after everything. Because remember, at the time we're saying words are important, definitions are important. We say that all the time. And it's funny because that's going to get quoted in here. When you say things is really important, and it adds to the context. And if something is true when you say it, and then additional facts or things happen, things can change. That's how life is. That's how life works. But the date of this sidebar in February adds some important context to it.
February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that Counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said,
you didn't answer me at first, which again leads you to believe she doesn't believe him or she thinks he had something to hide, right? If you don't answer me first, that's a problem. But then eventually you answer me and your answer is problematic, which leads me to believe that you didn't want to answer me. That's what I'm reading between the lines, right? I'm speculating there. I'm adding a little context to what it feels like she's saying, that she really doesn't believe Alan, and what he said reinforced that belief.
I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses?
The Commonwealth has the exact same batch as what we have for these witnesses. Now, later, Alan Jackson is going to be asked flat out, do you agree with everything Alessi said? And he is going to add some context and explain here a little bit. And he says, I thought they meant the report and the federal documents and the batch of documents the feds gave us. That's fine if you want to add that context and say that. And that's going to be important when we get to the mens rea, which is the mental state that you have to have as a lawyer to be found in violation of their professional rules of ethics. In Massachusetts, it's like 3.38 or something that Alessi's going to get to. Your mens rea and what your thought process is really important. So he's giving on the record what his thought process is, because that's not a true statement. Those words are not true. And the only way they become true is if he adds the context of what in his mind he was thinking. Like, what was I thinking? At that point, I was thinking, I thought we were talking about the batch of federal documents. I wasn't thinking about emails or things like that. And Eliza Little ends up adding, we didn't even remember the March emails exist until we went back and searched. That's also very true and something that happens. When you're dealing with a case for multiple years and there's thousands of documents, you don't remember every single thing. So when you have to produce something in discovery, you go back and you search your emails, you search your calendar. That's absolutely, I don't know, who's telling the truth, who's lying, but that is a completely normal thing that lawyers do. So I believe her with 100% certainty that that's how she found out about those emails. But in February, when they were producing the discovery, after the court ordered them to, this is a problematic statement by Alan Jackson that he had to give context to. He had to.
So I don't have any more information. I don't have any additional discovery. I don't
have any more additional discovery, which again is, I would say, not true, but at the same time, it seems like his context makes sense, because it's just not smart to say, I have no additional discovery, and then to be producing it like a week later. Like he had to know they were producing additional discovery. Either he didn't actually know and didn't think there was anything additional to produce, or he really was thinking just the federal batch with the reports and things like that. So, because he's not stupid. He's not going to say something doesn't exist and then produce it a day later, right? So it was either a mistake, a misunderstanding, or what he said is actually true, that he was thinking about a different set of documents. So to me, him adding that context is really important, but I do understand if the judge is like, this feels like it's not true when you said it.
Hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing, because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to.
And by the way, I'll just this is what popped into my head. That's basically a huge part of what this show is, right? Is what pops into my head when I'm watching these court appearances. And when she said, if you don't want to say anything, I kind of got flashbacks to the Alec Baldwin trial where the court was like, are you sure you want to take the stand, Ms. Morrissey, as a lawyer and say things under oath because you could be getting yourself in a bit of trouble? I got a little bit of that vibe when she said, if the lawyers want to say anything, right? Because now you're putting more statements on the record. Are you going to admit that what you told was a lie and things like that? That's what it felt like a little bit to me when she said it. John said, I need my lawyer, expert, and I didn't watch the entire day, but it seems like the defense may have lied, but was it intentionally thought? So, John, this is going to be one of the big questions we're trying to answer throughout the day is, was it an intentional misrepresentation of a material fact? And if it was it knowing? Did he do it on purpose? Or if he did do it on purpose, did he correct it? And there's no necessary timing about when you have to correct it. Ashley, Alessi was fired. We're about to get there. Bev will sanction defense in some way and Commonwealth will go unscathed as always. It's fine for the Commonwealth to speculate. Thoughts? I'm so overbiased, Bev. So we're going to get into who was maybe speculating, who was not, what the judge's response was when somebody was maybe speculating. Eric Post, Peter, hope the family is doing well and love the pickleball court. Any ideas why Jackson and Yannetti would have to testify in federal court? I don't know what's going on with that. I think it might have to do with the habeas corpus petition that they filed. I really have not been following that a ton. Have had a ton of other stuff going on, but I think that's why they're doing federal court. I don't think they're testifying. I could be wrong though. I don't know, so I shouldn't guess. If somebody in the chat knows, I'm sure they'll answer you. Gator Pam, any chance the defense will ask her to recuse herself after her biased behavior last week? Alessi seemed to be heading that way later in his speech. So when we get to what Alessi said, I will let you know what I think he meant by that. And where he was going with that. I don't know if they may ask her to recuse herself. She's not going to. I think that ship has sailed. I think she is the judge that is going to be on this case through the entirety of the first trial. Okay. We are going to take a break for an ad, and then we're going to get right to Alessi's argument. Listen here. I used to own a title company, so I know this is a major problem that just continues to grow. And that problem is house stealing by scammers who can transfer your title out of your name using a one-page document they file at the county. Then they can take out loans against it or even sell it. And the scariest part is you may not find out about this until collection or foreclosure notices start arriving in your mailbox, leaving you with financial and legal nightmares. Well, the best way to protect your equity is with Home Title Lock's exclusive $1 million triple lock protection. This service offers 24/7 monitoring, urgent alerts, and if fraud should occur, their US-based restoration team will spend up to $1 million to fix the fraud and restore your title. So who knows when the last time is you've actually checked on your title, but that's why I've partnered with Home Title Lock to offer you all a chance to make sure you're not already a victim. When you use my promo code LYK at HometitleLock.com, you'll get 30 days of free protection and a free title history report to lock in your peace of mind. And be sure you check out the $1 million triple lock protection details when you get there. So check out the link below because that's HometitleLock.com, promo code LYK. So Alessi brings his notebook. He brings his Trapper Keeper. He has everything tabbed out. He goes through the entire timeline from beginning to end of exactly what happened in this case. And I thought it was the perfect way to lay it out. There was absolutely some things that were repetitive. There were absolutely some things. He definitely is a kiss up, right? Judge, here's what I'm going to do. Thank you so much. He sounds a little bit like an appellate attorney, how he lays out what he's going to do and then does it. Appellate attorneys are famous for doing that. When I was on moot court, I did it every single time. It's exactly what you're supposed to do. And when you argue in motion hearings, sometimes it's a lot like appellate court where they're just going to ask you questions, things like that. But thank you, Judge, for giving me the amount of time for doing this. If I could indulge the court for another minute, has a bit of that Eddie Haskell. That's not a good explanation. I like it, especially when you feel like it's a judge that's a little adverse to you, right? You kill him with kindness. And that's what I think he does. There are going to be people that think he's a kiss up and they don't like it. And why? And the judge even like, you don't have to tell me what you're going to say. Just say it. It's like, I like when a lawyer tells you what they're going to do and then does it. It's easier to follow, right? And everybody can follow the argument. If you're reading the transcript afterwards, it's much easier to follow in the transcript because you said exactly what you're going to do. And if you miss the points you said you were going to miss, that's a problem. And I think all of that, from my perspective, I think he laid it out. I definitely think it was too long. I think he could have done it in less time, but he had a lot to say. And this is an incredibly important issue for the lawyers. If Jackson's going to get reprimanded and sanctioned, I almost said shanked, and sanctioned and thrown off the case, that is a really big deal. You can't take it lightly. You can't just worry about going too long. You got to say everything you need to say. He is an appellate attorney at his firm, Edward say. Well, that makes sense, Edward. I don't know Mr. Alessi personally, but that makes complete sense based on the way that he argues. Okay, so we start with the 320 email from Jackson to Wolf entitled Engagement. February of 2024, the federal investigation produced the ARCA report. So that's in February of 24, which is last year. Prior to this email, they get the report. Everybody gets it. The defense wants to engage these people as their experts. They didn't see it until March because they had 3,000 pages to go through. The substance is important. And he said their opinions never changed. And that's something he hammered away, is their opinions never changed. Their opinions never changed. Their opinions never changed. And the reason that was so important to Alessi is, what is the prejudice? If everybody knew their opinions and they never changed, what is the prejudice? And what I'll say is, I agree with him on one point, that is the main point in the substance of their testimony. There really was no prejudice there, but there absolutely was prejudice if payments were made and they told the jury no payments were made. So when were those payments made? What were those payments for? All going to be really important when we talk about, was there any prejudice in the first trial? Both sides had access to ARCA. He reads the email. Yannetti's not CC'd on it, which will be important later when we talk about that. Doesn't know if they required a retainer. Alessi absolutely, took the "words are important" slogan that we have on shirts and ran with it. Because if it was a word used, we can define it now and say what it meant. He's like, we didn't know if they required a retainer. There are many times where we don't know if experts require a retainer. And I'm going to be honest, and I'm just going to tell you how it is in my practice. In every case I've ever tried, we have experts on every single case I've ever gone to trial. Every case I've ever prepped for trial, we have experts, okay? So you go to trial on a small percentage, but you prep a ton of trials. Every one of them has required a retainer. Every single time. Unless they specifically tell you, I will do this for free, you're going to have to pay them. And you want to pay them, because I should say, sometimes if they want to do it because, they're fighting for justice, the right thing, but the bias, the other side is going to be able to argue the bias regardless. And it doesn't really matter. It doesn't bother me. If I'm hiring an expert, of course, the other side is going to say they're biased. We both have experts. That's not a big deal. And Alessi makes that argument, and he's absolutely right. But when you write the email, you're expecting a retainer, but the important part is ARCA was like, no, the pause email, as Alessi garnered it, was absolutely right. And to me, that's one of the best pieces of evidence for the defense. When your expert says, timeout, Zach Morris style, I got to ask the feds before we go any further. And that to me is great evidence for the defense that at that point, Judge, we realized this was going to be different. We thought we were just going to hire these experts. We loved their report. They were going to be our experts. We were going to pay them. They were going to come testify. And then we just can't do it. It's not going to be normal. This is not going to go through the normal channels. And once they knew that, everything was different. And that was a good point in Alessi's argument, that this just was not the same. Trial lawyers are used to doing things a certain way. And this case, as everybody knows, didn't go that way. Yannetti never mentioned ARCA in opening, which I thought was important because, again, they didn't know if they were going to testify. They knew this was going to be different. The judge created a remedy for any Rule 14 discovery issues with the voir dire of the witnesses. Absolutely. That's what we said in our last video. We'll listen to a little bit of Alessi explain kind of what happened in court at the prior trial, because he went back and got all of the transcripts as well.
They could not prep with us for trial. Court. And it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question.
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes. And
so many times throughout his argument, the judge is like, I agree with you. I agree with you. I agree with you. She agrees that, Wolf wrote it to Jackson. She agrees that that's what she said. So I started to think, okay, she went back and did her research. And of course, he complimented the judge and he was like, Judge, that's what I can always count on with you, is you're going to be on top of it. You're going to go back and review. And she did agree with him many times, which is why I think the betting odds changed from when she first walked out of the courtroom to when she showed up for this hearing today. And I think she's glad She's glad that she had time to go back and review the record and review everything that was said.
And I want to key in on, you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them, but that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes two people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says, that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So
because words are important and definitions are important. I love when you can use a Webster's dictionary in any case, because it's logical, it's simple. When lawyers want to complicate things, sometimes we've got to be like, guys, everybody relax. This is simple. We all know what this word means. And he's saying, I'll get into it if you want me to, but I don't think I need to.
I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. And I know the immediate response might be there. It might be at this point, wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point.
He's really good. He's really, really good. Lauren said, Alessi is the best lawyer I've watched. Law student, though, so a nerd about it. He kisses up perfectly. I understand why Your Honor would feel this way. Candor to the court is sacrosanct to me. I agree. I think he does. I get why people would call him a kiss up. I get why they would call him a suck up. But it's so hard for, like, Judge Cannone was like, all right, we don't need you to say that. And it's hard for her not to look kind of like a little bit of a jerk to him because he's being so kind with it. You know, some people get annoyed with that. I get it. I think he did a really good job personally. I did think it was a tad long, but I do think he did a really good job. Then they start talking about the voir dire of Dr. Wolf and how the judge put no limits on it. So they could have literally asked anything they wanted. There was no promise of payment or inducement or favoritism at the time. They talk about the comment about human factors, how he said it in voir dire, how he said it in direct. We already watched all that together in my last video. He literally went through almost what I did in my last video, right? He pulled up the voir dire. He pulled up the hearing transcript of what Hank Brennan said just a week ago, and he put it all back to back to look at what is the prejudice? Where is the lack of candor? Now, big chunks of time are when we talk about that sidebar and when we talk about the invoice/bill, but all of these other comments by Yannetti, all of the prior conversations with ARCA, all of the information that was given on voir dire, it's really hard for me to see any prejudice at all to the Commonwealth when it comes to what they were actually going to testify about. All right, then we get to, all right, the email from Wolf to Jackson, no Yannetti on the email, and he starts reading it. And again, this is going to be a big chunk of the argument that we listen to together.
Statement.
It's not here.
The time, let's say in March, etc. But clearly in June, the trial is going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face. And one of it is you can always tell what goes along with the email. So this is attachment Wolf-Qualls document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I'm well aware of that.
Okay, so
And the judge again says, I'm well aware of that. Love Mike Cosworth makes a good point. Paying a retainer is different from paying invoices for work performed. Paralegal here, we do so much volume with our experts that they don't require retainers. That's fine. But you know, and they know that they are going to get paid. And that's the question here. The question here is, did you expect to pay them? And that's important. That is the really important question, but good clarification. Thank you for bringing it up. Mackenzie said, on what basis could she exclude ARCA from testifying? Don't most experts get paid? What did they do wrong? Do you think she'll exclude them? Absolutely not. I think that ship has sailed so far down the sea, we can't see the boat anymore. Brennan made that clear. I pointed it out in the last video about how he kept saying, like, we're not trying to block ARCA. ARCA can come in. And Alessi did the same thing. He said 5 times, he said, we're not trying to block ARCA, even though they keep filing motions to exclude them. So I think that ship has absolutely sailed. I could be a little confused. It doesn't even seem like the Commonwealth is asking her to strike ARCA anymore. He wants to get rid of Alan Jackson, in my opinion. That is the focus of Hank Brennan right now. Deja vu, trial 2, is a writ of prohibition an option in Massachusetts? I don't know. I don't know if it would work in this scenario. To be honest, I'd have to do some research. Do they have to make a motion to recuse in this trial to preserve it for the record, or is it preserved for appeal since they made it in the first trial and she denied it? It's a good question. If I was actually trying the case, I would ask the appellate attorney I would have by my side while I tried the case. I would probably file the motion just because if I think this, brought up another reason, which maybe it did to protect it for appeal, but it may have protected it because they did it in the first trial. I don't know the answer to that for sure. Alessi pointing out the Commonwealth conflated Rule 14 with the other. Yes. Oh yeah. And he points that out multiple times, and that's important. Which is it? What are you asking for? What would be helpful is if you said, here's what I'm going to do with my argument, and you lay it out and say, I'm going to talk about Rule 14, I'm going to talk about Rule 3.3, whatever it is, and I'm going to talk about this.
So he prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony and that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor.
The judge did her homework. Maybe she watched some YouTube videos too. But it's she saw it. She knows that, yeah, Hank Brennan, which Alessi has fun with later, that came out. It wasn't hidden. There is no secrecy in candor with the court. By the way, if there was, there would be nothing wrong with that. And Hank Brennan admits that as well. There's nothing wrong with prepping your witnesses and saying, we don't need to talk about that. Let's talk about this. And if on cross, the other lawyer digs into that, you have to be honest as the witness and answer the question appropriately. But if it's not a line of questioning or a topic area that I'm going to get into with you, I don't have to get into every topic area with my expert. If the Commonwealth wants to get into it, they can. If they want to ask about it on voir dire, they can. He said it in voir dire. If I didn't want to ask it on direct, I don't have to. That doesn't make you unethical as a lawyer. But nonetheless, they did ask about it, and he did say it.
The next tab, and of course, it has the D&T of Dr. Wolf's experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Welch to Alan Jackson. Subject, Wolf Direct, attachments, Wolf Direct. So it's clear. And then if you turn the page, that is the attachment.
This is on Sunday night after voir dire and before Wolf takes the stand on Monday, which was a brilliant timeline that I didn't know, I didn't put together. This was all kind of new information and new ways for me to think about exactly what happened that Alessi did. That makes so much sense how he describes it. But if we're going to be technical, I don't know if I agree with where his argument lands and where it ends at the bottom line.
Is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCA, the frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the Rule 14. And we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I wonder.
So I'm going to pause it here because there are some things I really agree with and some things I don't agree with. What I really agree with is that when we get to the rule of professional conduct and professional responsibility, it does matter who prepared the documents and who knew what. But generally speaking, in a case, he makes it sound like, oh, it was divide and conquer. Eliza handled discovery. Jackson never touched discovery. Yannetti handled his witnesses. That's why he was on certain emails and not on others. Every courtroom and every judge I've ever practiced in front of expects, if you're the defense team, you've got to know what's going on in your case. I've had, big partners at defense firms be like, Judge, I'm not able to be there. And they're like, have one of your associates show up. He works for you. You have other lawyers. We're not going to delay this because you can't show up because you're on every case and your associate's not on any. You all need to have an understanding of what's going on. And it's not an excuse to say they were handling that, Judge, not me. So when I said something in open court that was completely wrong, I'm sheltered because the other lawyer was the one handling that. That's not how it works. That's not usually a reasonable excuse. Now, when it gets to the level of sanctioning getting thrown off the case, he explains how that's a much higher bar. But generally speaking, you can't just say, Yannetti gets up there and says whatever he wants. And if it's wrong, it's like, well, Jackson was handling that part. Generally speaking, that's not usually how it goes. It's a different kind of, dream team of defense lawyers they put together, but you have to be the defense team together. You have to be cohesive. You have to know what's going on. That is not going to be a reasonable. And it's, again, I do not think that's going to be something that we ever hear them use or argue in the future that, oh, that was Yannetti's problem. So when I was wrong about it, Judge, that's not on me. That's not usually an argument you want to make.
Underscore, it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
100% correct. He's 100% right. There's no way Jackson's sitting there like at his computer waiting for Dr. Wolf to tell him what questions to ask. I don't care how good an expert is. I don't care how smart an expert is. I don't care how many degrees an expert has, how many times they've testified, how much money they charge to testify. A lawyer thinks they know better, right? Sometimes we're right, sometimes we're wrong, but we think we know our case best. We know what questions we need to ask. We know what information we have to get. We know what we're arguing to the jury. So there's no way. We'll work with the expert, of course, and it's great to work with really smart experts that know what we don't know. They're much smarter than us most of the time. So again, we always love to work with them, but there's no way that Jackson was sitting there waiting for somebody else to tell him what questions to ask Dr. Wolf. And the timing of that email for Dr. Wolf just goes to show even more, there ain't no way that it even affected the testimony or questions Jackson was going to ask. No way, in my opinion.
Explanations of the trial until he got it. I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other.
How about that? The judge agrees like that. I don't think there's anybody here that thinks that Jackson was waiting on Wolf, which means it's not material. The info that Wolf emailed Jackson is not material, and it definitely wasn't prejudicial. The only bit of prejudice I can think, because I'm doing my best, okay? In case you can't tell, I am doing my best to try and see it the way this person sees it and the opposite argument. That's what I try to do. That's what I try to come up with in my brain. That's what I do in my own cases. I feel like you got to know what the other side is going to argue. So if I'm thinking about where the Commonwealth can pull prejudice from this email is just purely that Wolf sent Jackson ideas of what to ask him, and therefore Wolf was playing for Karen Reed's team and he wasn't independent. How important would that have been? Now, I would say after hearing from some jurors, it wouldn't have been important at all. It wouldn't have made a difference at all. But generally speaking, is that some prejudice? Maybe. Is it enough to have some huge sanction? Absolutely not. No way, not even close. And Alessi quotes some of the case law and the deplorable things lawyers have to do, like sending your accountant about accounts that you know about in a divorce case and saying, oh, I don't know those accounts agree, Judge. I didn't know those accounts agree. And it's like 2 days ago, you told your accountant to protect these accounts. Like that's what you have to do to get these kinds of sanctions. And Michelle said, Judge Cannone asked if the case law involved pro hoc cases. Yeah, she's definitely trying to parse out. Do I have a lesser burden to kick somebody off if he's pro hoc versus if he's a Massachusetts lawyer? That's important. She wants to make sure she's got the case law right, and she's asking the lawyer the questions, and they should be able to answer those questions.
An important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring your honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, 1 day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligation, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it. It came to my mind. We know what the standard is, but I want to underscore.
So what I'll say is, with him, practically speaking, I agree with him. Would we think on the eve of trial Sunday? I'd be annoyed, frankly. If an expert sent me that, I'd be like, oh, now I got to disclose this. Okay, here it is. I didn't even look at it, whatever. Maybe he didn't even see the email, to be fair. Like, there's definitely stuff that happens Sunday night before Monday when I'm going to trial that I do not see. I don't speak to most people when that's happening, right? But if we're going to be technically, they should have turned it over as reciprocal discovery, and it should have absolutely been something disclosed, especially because of the line of questioning and the fact that they were going to push so hard that they were independent experts. So technically speaking, by the letter of the law, it was a violation. I think Alessi basically agrees with that, but there's a difference in the law, right? When we talk about, and we just rewrote a bunch of our rules in Florida, added a bunch of sanctions for lawyers. When you either intentionally do something or with reckless disregard do something, you should be sanctioned. But if it's really accidental or something that lawyers overlook, and it's like, we understand excusable neglect is the language that we use. To me, that sounds like excusable neglect. Of course, people are going to say, oh, you're a shill for the defense. Of course, that's excusable neglect. Wait till you hear what I have to say about what Hank Brennan did. That some people are not going to agree with, but I'm going to just be honest with you about how it works to be a lawyer in these positions with years and years of arguments that you have to make. Okay. So I think it was a violation. I think it was excusable. I think the fact that the first trial is over, you cure that now by forcing them to give you everything.
The connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. not even to bring in the voir dire, that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think, perfectly tailored to the situation to basically say, I don't, as the court, understand. These folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of we got the report. And all we had is emails in March, right? That are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up. Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, a great deal of my work is in the field of lighting and visibility, so there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Litt? No, that's correct. Mr. Yannetti? No. Fact. As a matter of fact, you had never heard of this case. That's correct.
And we watched all this together, right? And I said the same thing. What he is saying, all of those words at that time were 100% true and correct.
Page 3670. Line 10. Question. When did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer, correct. Question. And that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer, correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say, this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100.
People are not going to like that, but it's true. At the time when he's sitting on the stand, whether or not you believe what's coming in the future, as far as we got something out of the blue, at that moment, at that time, the answer was no, and that is true. TXRN said, what is Rule 14? Sorry if lame. It's a discovery violation, saying you didn't turn over the documents in discovery that you should have, or that you're supposed to, that you're required to by rule, or that somebody actually asked about. TJ said, why do you think Alessi is the one making the arguments when it seems that matter almost entirely pertains to representations made by Jackson Yannetti during the first trial? It's the perfect way. It's almost like there have been cases where a lawyer sits at counsel table the whole time and he doesn't get up until closing argument, and he gives the closing argument, or she, and says, I am the 7th juror or the 13th juror. I've been sitting over here and let me tell you what I've seen. Let me tell you where I saw the evidence going. He sits there. He gets to look at it from afar. He also has some plausible deniability. He can say stuff like, I wasn't there, just like Mr. Brennan wasn't at the first trial. Neither was I, Judge, but I'm reading the transcript. I watched this. I saw that. So it kind of levels the playing field, right? And they're all talking about what other people are doing. I think it's a great way to set up these arguments, and I think it worked. I think it worked.
% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with the March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. To the best of my knowledge and my review of all these facts and discussions with counsel,
things like that. To the best of my knowledge, review of all these facts and discussions with counsel. So he's kind of CYA as well. He goes through a lot. He goes through everything was true at the time. He said Wolf is nervous. That's his speculation. Judge shuts him down. She doesn't shut down Hank Brennan later as much. But he doesn't call it speculation. That's the problem. And that's to the fairness to Judge Cannone. If Hank Brennan would have said, Judge, I'm going to speculate here like Alessi did, I think the judge would have shut him down. He didn't. He just went forward and decided to do it. He talks about how the United States Attorney's Office did not want the findings to change in any way, the findings of the ARCA experts, and they never did change. Then he gets to the actual discussion about the invoice. So let's jump there.
And whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, the findings of ARCA being that the vehicle did not come into, Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it, we don't run from one word or line in this invoice.
They don't run from one word or line in that invoice. He says stuff like that, but there are problems in there. There are problems in there. BB said, Peter, when you use air quotes, sounds like you don't believe a bill from ARCA was out of the blue. Here's what I say. I don't know if it was out of the blue or not. There's no correspondence that they agreed on an hourly rate, which we would always agree on. If there's a cap, what expenses we would cover and would not, all of that we would have beforehand. Did they expect to pay them? They say no. Here's what I'll say. I don't know what the truth is, but unless you can prove they're lying, like, again, if you have an email saying, oh man, this bill is going to be fat from ARCA during the trial between Yannetti and Jackson, if there was like an email like that was produced where you knew you could prove they were lying, without that, it just does not rise to the level of the lawyer misconduct that they're claiming in this case. You would have to assign motive and say that they're lying and just find them. As the fact finder, the judge could say, I find you not to be credible. I think you were lying. I don't think you got it out of the blue. I think you knew about it. And frankly, if she ends up throwing Jackson off the case, that kind of has to be what her finding is, that what he said was not true. Were the feds planning on paying ARCA if there was no retrial? I don't know the answer to that, but I think that's at least a plausible explanation from the defense that we thought the feds were going to pay. I mean, just listen back to before the last hearing, me and my dad's conversation. That could be what the defense was saying. Who cares who's paying them? We need them to come out of trial. They didn't send us a bill. By the way, in I think every case I've ever tried, I had to pay for trial testimony prior to the expert showing up and testifying. Now, sometimes there's expenses or additional costs, or sometimes I'll pay trial prep afterwards because we don't know how much prep there's going to be. But if it's $5,000 or $10,000 for them to show up and testify for half a day or for a day, I always pay that up front before. So I think it is plausible that they just didn't know. And they were willing to take that chance. Are they going to send us a bill? I don't know. We haven't paid them anything now. Hopefully we won't even have to pay them. I think that's very plausible. But I don't know, right? I don't know. I'm not one to call people liars just because I don't know for a fact it's true. And I think people jump to that conclusion too quickly.
But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March. And it wasn't even any discussion about particulars, et cetera. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the point.
When you're arguing a motion hearing like this, you're not supposed to be testifying. So sometimes if you are the lawyer involved, you start saying, this didn't happen, judge, or this happened, judge, or that happened, judge. And then you start testifying as opposed to arguing. And I think putting him in this position to make this argument is just cleaner and easier. Michelle L., I always learn a lot here and appreciate the objective discussion and analysis. So the defense is claiming they didn't know they were going to be billed later on, and Hank is saying they should have known. It's not should have known. Should have known does not work here, right? Because either you knew or you didn't know, and if you knew, you got to prove it. The knew or should have known thing is a standard that's not really how it works here because of the federal investigation. And it's like, we never knew. Hank Brennan says it a million times. I don't know what's going to happen when I send a 2E letter, but I know it's probably not going to be good. It's like, you never really know what's going on with the feds. Somebody else saying, why would the feds pay this expert to come testify for Karen Reed? I don't know. They probably won't. But if they do, they have them on retainer. So maybe it's just part of their work in this case. Maybe they were, I don't want to get into, what might be happening is the federal investigation dropped or their charges or not. What was the investigation? I don't know. But maybe they considered it part of whatever the work is that they were doing. I don't know, is the point. I don't know. The Racine. Peter, did Bev blow this out of proportion? She has never shown grave concern like this towards law enforcement or Commonwealth when there have been many instances of grave concern for the woman on trial, my opinion. Definitely does not feel like the same response attached to similar actions.
Punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount.
AKA Karen Reed was shocked about the invoice coming in and in the amount. So she, maybe in her conversations with Jackson Yannetti and listening to ARCA on the stand like all of us, whoa, they're not paying for him? Now, the jury didn't seem to care about that very much. But we and Karen Reed was all like, wow, that's crazy. And then they bill her and she's like, what? Now, you might not believe it, which is fine if you don't believe it. I would like something more if I'm going to call them liars about this. I really would like more. Same, just hold your horses till we get to what Hank Brennan says and how everybody feels about that and then how I view it.
So what happened? And this is, Your Honor, objective. These are recollections, information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
So there's the big question. First off, he says they called the U.S. Attorney's Office as some kind of proof that, of course, we didn't know, things like that. But did they pay it was the big question, the $1 million question. He says, yes, they paid it. We can lay it to rest. The defense paid ARCA for trial prep and cost reimbursement, travel, things like that for trial one. But when did they pay it? That's the important part. When did they pay it?
For anything. There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, not understand. The date of the invoice is July 12th. And I think I can get you.
I'm going to skip a little bit because they paid it on July 25th, I think is the answer.
Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the substance, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that?
Yeah, it was July 25th, I think. Emily, yeah, and we've mentioned this a couple of times. So if there are more comments like this, I will put them up. Then they get to the hearing on February 18th, and he starts discussing what exactly Hank Brennan did there and how important it is and why that's why we're here, all because of how Hank Brennan handled himself on February 18th. But we are at the 1 hour mark, which is usually when I end my videos. I like to keep them around an hour. I assume we don't want to do a part 1 and part 2 of this, especially because we've gotten so far in it already. I know it doesn't look like it, but there's a couple huge breaks coming. But go ahead and hit that like button, and let's just continue going forward with some overtime here and push through to get through this entire video. Also, wouldn't the fact that he's an appellate attorney make his point taking Jackson off would be an appellate issue hit harder? I mean, I think it's important and it's going to hit hard regardless of whether or not he's an appellate attorney. Michelle, after being subpoenaed by the court, could an expert refuse to testify because of non-payment? Aren't they ordered to appear? So they're subpoenaed by the lawyer. Yes, they would still probably have to appear, but in certain jurisdictions, the expert could say, I wasn't paid for my services. They could maybe challenge the subpoena and that they were only going to come if they got paid, or you put them up there and they're not quite as good of a witness as they could have been if you would have paid them, or they say they owe me 10 grand and they didn't pay it. And then the Commonwealth's like, oh, look how the defense treats them. It's never a good thing. It would never actually happen, but you probably could force them to show up and sit in the chair. What they would say in their testimony might not be as good as you want it to be. Judge Cannone will either disallow ARCA or boot Jackson. I think she's made up her mind that the defense will be affected in one way or the other. There's no way she's going to boot ARCA. There's just no way. And I'll tell you what my thought is about Jackson a little later in the video. Michelle, the Commonwealth arguing they should have known and maybe did. Maybe did know is just not enough in my opinion. It's not enough. Let me jump ahead here.
Obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial.
It's also smart to use what the judge has used against you in an argument. This is a new trial, and I've said that from the jump. Would this have affected the first trial? Really is not a consideration of the court. Did lawyers lie? Did they falsely and fraudulently, knowingly misrepresent things to the court? That's a big deal. But prejudice during the first trial should really not come into play. That trial's over. We need to make sure there's no prejudice and problems for trial 2.
But I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that
I jumped ahead too much. It's supposed to be here. My bad. We backed it up a few minutes.
About the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them, and I'll go through each one and number them. Or deprive the defense of an ARCA expert in this case. Very important, because from my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly. So now we go to page 54, and this is going to be in some points a line by line because the words matter. Line 5, and this is again is Attorney Brennan. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCA experts? February 12th report?
I think they're saying they don't know about the payments. It's probably what they're at least pivoting to now. because that's really the only thing they could say they really didn't know about was the payment and then the script or outline or whatever you want to call it.
A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it biased, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office and their federal investigation.
It's so funny because lawyers, and I find myself doing it all the time when I'm doing these videos, it's like, I'm not going to say our experts are biased for us, but it's like, there are experts because they testify in a way that we agree with. We're all on the same page, especially if you're dealing with like scientists, engineers, doctors. It's like, they're not going to lie. The doctor, though, that sees it the way that we see it is obviously we're going to hire. We're not going to hire a doctor that may see it differently than we see it, than our case sees it. It's like, yeah, that's how it always is. And the Commonwealth basically tried to make it seem that way in the trial. And it seems like they did a pretty good job. The jury felt like somebody on Karen Reed's side was paying ARCA. Maybe it was true.
Next, online.
Maybe feds saw it the same way.
12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense.
He's right. The reason this is a big deal is because Brennan was incorrect and said this was all from the feds. I don't think we ever have that pause and a new hearing and, all of this stuff if he didn't run with it, the first argument that this was all from the feds and not, in fact, from the defense.
It was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that.
I think he goes back later and figures out it was February 13th, and that was a Thursday before a Monday. Was it Thursday before Monday or Tuesday? I wrote this down. I was like, everybody that's on Karen Reed's side is going to be like, they had 5 days. Everybody that's on against Karen Reed is going to say they had 1 day, just Friday, because you have a weekend. It was sent on Thursday night. They were going to have to start arguing on Monday. A couple days, right? A couple days. They turned it over, not in an inordinate amount of time, but within the discovery period, which we're going to talk about here in a minute when we get there.
Date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest. You know it better than I do about counsel's obligation to turn over discovery, et cetera, et cetera. So,
all right. So he hit it right there. So let's talk about that for a second, because this is a question I got in my DMs a bunch. What did he mean by this? By the Commonwealth not filing their certificate of completion of discovery or that they've turned over all the discovery. The discovery deadline, I think, is next month. I can't remember. The defense was trying to fight what they had to turn over from ARCA. They lost, and the Commonwealth hadn't completed their discovery. When the defense turned over all of this new information on ARCA, if you want to call it that, the payments, the emails, the email from back in March, they did it within the time period allotted. You're allowed to fight things in discovery. You're allowed to lose. And once you lose, the judge gives you a certain amount of time to turn everything over from ARCA. And what did they do? When the judge told them they lost, Eliza Little went back, did her search, and turned over everything in ARCA. So for trial number 2, why this is so important, there is no discovery violation. There's no prejudice. There's no sanction with regards to trial 2. Nothing. Because we are still in the discovery period. They fought the ARCA discovery. They lost, so they turned it over. Really, the only question here is, did Yannetti and or Jackson lie to the court knowingly and misrepresent material facts and fail to correct them? That's really the only question in front of the court. That's the point he's trying to make with this discussion. Obiner said, are you going to cover at some point other day the rulings from yesterday? Commonwealth didn't have to provide the video metadata. How is that okay? Yeah, not today. Maybe another day. I'm sure maybe we can mix it in with another video where there's a little bit less, but just too much today to get through.
So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false. Okay. So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days.
Yeah, and we listened to that part already before I backed it up. He talks more about how Brennan said he read the info. He asked for more. He read the transcripts. He asked for more information from the feds. He again mistakenly said, I got all this from the feds. He repeats that a little bit. Brennan did not read things in chronological order. Brennan read the March email as a quote, but it was wrong. He left out the word pause, and that's really important. He goes to the part where Brennan says that the defense provided ARCA the outline, and Cannone, already said she realizes that's not true. So there were all sorts of things that Hank Brennan said that were just incorrect. Now, I believe, as I said in the prior video, and Alessi says it too. I don't know if I'm going to play a clip of it or not, but he says, I truly believe that Hank Brennan believed that was from the feds. I don't know how, because we sent it from our email with our Dropbox link. So how would he think it's from the feds? But I'm going to give him the benefit of the doubt. I do the same thing. I think Brennan made a mistake, and I think he got up and corrected it. Now, Alessi's going to have a little bit like, yeah, he got up and corrected it, but not until your honor said X, Y, and Z. So he thinks Brennan didn't correct it on his own, but felt like he was forced to correct it, which I think is interesting and probably a bridge further than I would go. I would say Brennan was dead wrong and has egg on his face for making those claims that this all came from the feds. He corrected it. I don't think he did it intentionally. And if he did correct it. So I don't think, he violated that rule of professional conduct. But I think he should understand that people misspeak. People misunderstand details. People miss things. They don't remember an email from a year and a half ago. It happens. And when Alessi makes that argument, I wanted to stand up and clap because that's how I felt this whole time. And some people may not like it, but we're going to get there. This is hard and crap happens, for lack of a better word. Doesn't make it perfect, but we have to understand that. Let's see what else we got. So I do want to play the part where he's like, how in the world does the Commonwealth think they got this from the feds? Because I do think that's a good argument that I did not make and I did not think of. Obviously, I didn't know how they sent it in a Dropbox with the title, but this is good context. And people are saying, I don't agree. He lied. He's a liar. That's fine. And that's fine. We can agree to disagree on that. And Judge Cannone is going to be the finder of fact. If she thinks Brennan lied, if she thinks Jackson lied, and everybody that's sure that somebody lied on purpose, it should be hard for you then to say, you can't say that person lied on purpose, because if individuals can know for a fact that somebody intentionally lies, then individuals can know for a fact that somebody intentionally lies. I think it's difficult. I wouldn't want to do it unless I had cold, hard evidence of that. That's what I would want to do, or that's how I would look at it.
And I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much. How is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top, and then we continue on page 59. Your Honor, understandably says the court, what is the date of that? Mr. Brennan, it's not dated.
When I said date, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately.
And let me be clear. 10 untruths proven today by Bob. I agree. They were wrong. What he said was absolutely wrong. But Jackson, in my opinion, was wrong in the sidebar conversation saying he never paid him. Jackson added context to that. Brennan came up and corrected it and said the defense gave it to me, not the feds. So again, that type of stuff, to me, I view that similarly. I think Brennan said a lot more things that were wrong, but I think he has corrected the ones that he agrees with that believes to be wrong. Peter, what is the standard to meet a finder of fact? Sorry, I worded poorly. So it's not a standard to meet it. In a jury trial, the jury is the finder of fact. In hearings, in bench trials, the judge is the finder of fact. The judge is always the finder or decision maker as far as the law goes. So in a jury trial, the judge decides the law, the jury decides the facts. But in hearings like this, the judge decides the facts. In bench trials where there is no jury, the judge decides the facts, and that's what we call finder of fact. Hank didn't correct all his lies. Okay, I don't have them all memorized, the 10, but the ones that I remember that he did come and correct.
And understandably, he says, what's the date of that? Here's the answer, Your Honor, no. It's not dated. It's not dated. Now, let's please just...
As Alessi has already explained, it's pretty easy to figure out when that outline was provided with some context of the emails. That's obvious, and I think he's right. And I think Brennan potentially, again, is that a misrepresentation or is it technically true, right? If words are important and if they're true at the time for when the defense says them, and we say stuff like, Brennan said the outline's not dated, technically that is true. Now, did he really try and go back and figure out from the context when that outline was from? No. Should he have? Yes. And Alessi did it, which is points for Alessi. Being the more prepared lawyer with more answers is always better. The judge does ask, again, another $1 million question. Was this information disclosed prior to the witness testimony? Alessi said no, which he said before, and that's the technical problem. This was a document that should have been produced in discovery. Even if you got it, the night before, you should have produced it and you didn't. Now, how prejudicial is that is the second prong of that, but technically speaking, it was not produced when it should have been. Some repetition in there. $24,000 bill from ARCA. We didn't know about this till the feds told us. He doesn't know what the date of the bill is. That's what Brennan said. And then we'll get to another little chunk of his argument here. He loves quoting Brennan, right, from that prior hearing. And I don't blame him because Brennan was trying to put on a little bit of a show at that hearing. They're his supporters, and the supporters of the Commonwealth loved it and ate it up. Just like when Karen Reed's defense puts on a little bit of a show, their side loves it. But when it goes wrong, you can really step in it, and people can use. It's like one of the things in mock trial, which I actually do in my real trials too, is whatever the defense's theme is, I do try to flip it, especially in my second close. Like when I go last and they cannot get up again, I will try to flip their theme and use it against them. And when you do, it's a chef's kiss. It's amazing. And he's going to use Brennan's words against him here.
Then there's a lot of statements made. Sometimes parties pick sides, agree, blah, 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 blah. And then it allows the ability of one side to be...
I do love that too. Blah, 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 blah.
Ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than an illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion. It's a statement of fact. Statement about federal investigations that were these are not ghosts. We're not creating it. But I'm not going to go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpret it, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line. Page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions.
I mean, I literally had the same thought that Alessi did. When I did my prior video, I'm like, this is great for Karen Reed's team. He is not even objecting to these witnesses anymore. It's the same exact thought I had that we talked about in the last video. And I think he was very smart to highlight it. Whatever happens with the lawyers happens with the lawyers, but ARCA should not be touched. Gina said, hi, how did ARCA know to appear for voir dire? Also, what more does the state want from ARCA other than findings, opinions, and reports? They want to know bias. Bias information is, did you get paid? What conversations did you have with the defense? How much did you guys prep? They're absolutely entitled to that with every expert, every witness, frankly. If I pay a regular witness, they should know about it. It's absolutely fair and should be. And the judge told the defense to reach out to ARCA and get them scheduled to come in for voir dire, so that's how they knew.
I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that was based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now it comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and frankly of the moment in this trial. And the reason I got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this, the court saying the greatest, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the...
By the way, smart lawyers don't use words like lie after lie, because that's going to draw an objection or a reprimand from the court. Inaccuracies on inaccuracies is something that can fly under the radar, but means exactly the same thing.
Several and serial inaccuracies. They'll break right in the middle, and then the court comes back. And I understand. I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit.
In this case?
No,
I'm
I'm
saying generally, you've had this issue in other cases, or do you mean?
Other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break. So we didn't get an opportunity to stand up and say, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right.
That was a great point that I didn't think of as much on the last hearing. That he's absolutely right. Would be easier to know if Brennan lied if he had actually put this in a signed motion, not ambushed the court and the defense, and a signed affidavit, which was the point that Alessi just brought up. And that's an amazing point, because you don't get the same benefit of the doubt. You don't get to correct what you said 5 minutes later if you put it in a sworn affidavit. You are dead wrong, and you better explain yourself if you just made an inaccuracy under oath. So I definitely think that's a big deal. Definitely. That's a problem. Like, you have to do things right. Judge Cannone should have said, Mr. Brennan, we're not doing this today. You didn't provide it to them. Write it in a motion, provide your affidavit, give it to the defense, and then we'll see what this is. It should not have been even taken up if he did not provide all this to the defense.
So the Commonwealth just provided the court with information, and I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant, but Your Honor well knows what Your Honor said. But it certainly...
And he's talking about the judge's viral comments about her grave concern. And he's right. And this is where he starts to hint at something that they might do.
Had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key. So you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then, when the the reality hits, that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds, and the defendant didn't turn it over. So what does the Commonwealth do?
I know a lot of people are going to agree with him. I disagree with him. I don't think that's where it hit. I think somebody told Brennan and he was like, oh crap. Because obviously if you're going to say that and you know that what you're saying is not true, that the defense can get up and say, we provided this to you. If Brennan knew the defense provided it to him, but he said the feds provided it to him on purpose, he's just walking into the worst trap ever. So I think potentially it was a stupid mistake. It was not intentional. That's how I see it. I could be wrong. And Alessi's saying he only fixed it because the court asked for the backup documents. Everybody's free to make the conclusion that they get to.
Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake. My whole predicate for my whole presentation was I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, you know what, I don't even know if I would have had the courage to say no before I might have asked for a sidebar and come up and said, Your Honor.
He's like, it was so embarrassing. What Brennan had to do was so embarrassing. I might have asked for a sidebar. I agree with him.
This is that. But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on.
He's right. The Commonwealth didn't just get to argue once. They got to argue twice. Judge Cannone comes back and is like, we're continuing. The Commonwealth's like, wait, we want to say something else. And that's true. And that's not due process.
If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another two-week request, 2000.
And he mentions how Brennan says, I think I said it was the feds, not the defense. But Alessi's right. If you were going to come clean, he should have come clean the way that said, my whole predicate was wrong. Let's change that. But he didn't want to quite admit that big of an inaccuracy, I will say. But legally speaking, he did correct his error in open court, in my opinion.
So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the changing position on February 6th that the contract was ended, but that parties could contact ARPA. Obviously, the Commonwealth is in no position to contact ARPA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it because that would naturally preclude the defense from retaining them. Yet at the same time, the Commonwealth, for the fourth time, has moved to strike our ability to use ARPA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I harken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements, 10, before Your Honor caused the pause. So, coming to what happened then. The Commonwealth having not giving us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got, because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciate that. Because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is where counsel saying to the court it isn't accurate, I wanted to make sure I can do the best I can. Now, I may have made a mistake here or there, but I just wanted today, but I want to make sure that I recognize Your Honor's giving us that week, and we try to take the best opportunity for it. So what happens? what happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied.
That's the kicker. I don't know if this can be remedied. Around the world, including potential jurors, the jury summons are going out. All these defense lawyers have been called liars and cover-ups. Are some of our most important evidence and experts, they've just been destroyed and their credibility destroyed because of the inaccuracies by Mr. Brennan and then a really quick fix of his inaccuracy. And if that's true, and they've created this much prejudice, I think a motion to dismiss is coming based on that. I know we have the motion to dismiss for prosecutorial misconduct. Maybe it's going to be included in there. Maybe it's going to be an additional motion to dismiss. Maybe they're going to file a motion to recuse Judge Cannone because of her grave concern comment, which will get denied. But we are not only stacking inaccuracies, but also stacking appellate issues. These are major appellate issues. You can't in open court. And here's the other thing with this case. If you're on one side or the other, kind of like jurors as they go throughout a trial. Once you kind of start to get on one side or the other, anytime you hear something that agrees with what you think, you go full bore. And everybody against Karen Reed goes full bore when they hear Brennan say all that stuff. And his little change didn't change the way any of them saw anything. Now, the opposite is true too. When they call Hank Brennan a liar with all of his inaccuracies, I think people jump on it full bore. Both sides, I think people start to and I'm not like accusing anybody of being a bad person for this. It's just a natural inclination of the human brain. When you start to see something you feel really strong about, justice for John O'Keefe, justice for Karen Reed, justice for both of them, the justice system generally, to shine a light on corruption. It's hard to get that train back on the tracks, put it back in the station, whatever that phrase is. And if that's the case, and you have violated the defendant's right to a fair trial, it's over. And that's kind of what he seems to be arguing here. Although I've missed both the quotes. I missed the words matter quote. I don't know if I played it or not, but he also talked about being a lawyer on these types of cases is hard. I want to back it up just a couple minutes to see if I just missed it right here.
Has provided us the emails that I read. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to
Because I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, you got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this: being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 50.
Mistakes are going to be made. Being a lawyer on a case like this is hard. Being a judge on a case like this is hard. And I couldn't agree with that more. I really couldn't. All right. Then he gets into that 3.3A argument about, lawyers knowingly making a false statement of material fact or law or failing to correct it. We're going to jump to some of those arguments now. Double overtime, double secret probation. It feels like here.
They do that when the Commonwealth, based on their witness list, recalls them as that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson. This is the key context. I can tell you this, the Commonwealth has this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days technically to turn it over, but it got turned over on the 12th. So then it continues on, is important. The court, if I don't exclude it with other sides seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided.
So that is basically the discussion at sidebar. Again, we've been over this. Jackson provides context, says he thought they were talking about the stuff the feds gave him, not the emails they ended up turning over. Then he gets to the Sixth Amendment argument as far as even if lawyers screw up, if they correct it, which Jackson did by providing the discovery, if there was a materially untrue statement, he first argues it was not done intentionally or knowingly, but even if it was corrected just a few days later when they actually produced the discovery. Again, would be really dumb for any of these lawyers to lie and then produce the exact document that proved that they were lying just minutes or days later. But again, those are the arguments some people are going to make. But when he gets to the Sixth Amendment, he says, some of the rules are down here, but the Sixth Amendment right to a fair trial and counsel of your choice is all the way up here. It's not absolute. He does cite some cases. The judge asked if there's pro hoc vice cases. He says yes. He says in order to really revoke that, you have to suborn perjury, which can bring us back to the ASAP Rocky trial. And then this was an interesting comment he made during this argument I want to listen to.
Not adversely affected by whatever the counsel may or may not have done. Well, I want to be very carefully clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th, there were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument. I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I provided a factual legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say this a camouflage or shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we made mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really.
He used words matter, dictionary definitions, and everybody just take a deep breath. And I agree with him. We need to move on from this. People made mistakes. Let's correct the mistakes. Let's make sure we move forward with candor and everything being appropriate. The sidebar was 3 weeks ago. I agree with you, which is why it's problematic. But literally, you have the sidebar, then they produced the discovery, I think like a week later. They produced the payments that we're supposed to believe that he said never happened, and he meant that at the sidebar. And to me, that's just dumb. I can't believe that was knowingly false, that he knew what he was saying at sidebar was false and then proved it was false a few days later. Alessi says he never seen Jackson deal with discovery. Bev cuts things short. Let's cliffhanger last all week. She did this in the trial too. She is going to be in trouble. We'll see. All right, let's get to, first she takes a break and then she has a question for some of the lawyers. She asks them, do you dispute any of the facts? Alessi said no. And then same to Jackson. Let's listen to Jackson from his own mouth answer this question.
She didn't know.
No, what he said was entirely accurate.
Okay. Mr. Jackson, same questions.
No, and I would simply elucidate with regards to the February 6th sidebar comment. As I look back at I didn't remember making a comment one way or the other. I didn't remember that sidebar.
I did.
I'm sure the after the transcript. I did as well.
I did long before.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript was very clearly the federal batch of information, what we refer to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small.
Invoices, payment.
No, nothing. I was, because the context of what Mr. Brennan was talking about being frustrated about were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Hold on.
And Ashley, I agree. He just shouldn't have said it. And he did, but they've shown the payments now. There's no harm, no foul. There's no prejudice. They know it and they can ask ARCA about it in trial number 2. And I just disagree. Like, I know what I want as a lawyer at trial from these experts. And bias and what you've paid them is, and bias, again, when a lawyer says bias about an expert, they really mean prep materials. How much did you talk about what you're going to say and tell them what to say? A lot of times, sometimes I'll get something from a lawyer that says, say this to an expert, and I'll use that. And I also don't always get just what they're paid in this trial. There are some experts the defense used that have made $3 million over the last year and a half working for some of these car insurance companies, coming and saying the same thing over and over again. I want that, and they know it. So when I ask for the discovery, that's what I'm asking for. Okay, then we get to Brennan's arguments. He said you should consider repetitive violations, which he thinks the defense has here. The defense portrayed ARCA as independent, no bias or collaboration. I agree with that. But basically, it's just a candor argument. It's not a Rule 14 argument anymore. At least didn't sound that way from Brennan. He said it still isn't complete. And then he starts talking about, I wrote question marks here because he starts talking about the murky relationship between the defense and I believe he says the United States Attorney's Office, which how often do we have that where there's a relationship at all, murky or otherwise, between the defense and the United States Attorney's Office, the federal prosecutors?
The iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very...
So is it like they're in cahoots? Because that seems like a good thing for the defense. And do you know what I was thinking this whole time? Maybe this is bad of me, and maybe I shouldn't have been thinking this. But you know what I think would really just solve this entire problem? Let's just be honest with the jury. These pesky rules of evidence are so annoying. Let's just tell the jury all of it. Let's just tell the jury, listen, members of the jury, the feds hired ARCA. ARCA did the investigation of the car. They gave their reports. Either side could have called them. The defense called them, and because they called them and they came and testified and did prep and flew down here, the defense paid them $24,000 to come and testify. Just tell the jury that. Who do you think would object to that? Which side do you think would object to us just laying it all out for the jury? And sometimes I'm like, lawyers are so annoying. We make things so complicated and we're so worried about this bias when in reality, we just created another one. Somebody posted in the chat earlier, the jury felt it against Karen Reed because some secret third-party agency paid for the experts. We got that context from at least one juror. Was that the truth? I don't know from all the jurors. But by hiding one bias that we're worried about, if they hear the words FBI, they're going to be biased against the Commonwealth, we've created another bias. And that's so often what happens. Like in a lot of my cases, I can't talk about the truck insurance that the trucking company has. So it's like then we're hoping the jury sits over there and is like, oh, this poor company, they don't even have insurance. It's like, no, they do have insurance. They're just lobbyists that create a rule that I can't say it. And that frustrates me. You know, we're doing all of this because we're trying to hide true information from a jury. And it's lawyers that create these rules. Okay, let's listen to more about the murky relationship.
Unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th when ARCA is actually billing the defense for their works before the voir dire. There had to have been...
So this is another thing that I see a lot of this, right? A lot of this back and forth. So ho axon, and then tell them the FBI investigation ended. So I don't know if it did, but let's go with that. Let's say it ended. Fine. If you want to go down the road, I don't think we need to go down the road. I would tell them as little information as possible to get the truth to them about the experts. But if we want to go down the road and we want to say the investigation ended, tell them what the investigation was about. If you noticed, I didn't say that. I didn't say they were investigating anything. I don't know for a fact what they were investigating. Were they investigating the prosecutors, law enforcement, the investigation, the prosecution? Were they investigating Karen Reed? Were they going to charge her with a federal crime? I don't know. But if we're going to say the investigation ended, we probably have to say what the investigation was. I just, that's where you get into some trouble, right? That's unnecessary information to me to tell them what the investigation even was. Because to even say they were investigating the Commonwealth or the investigation, that's undue prejudice that we don't need. But the fact that it was the FBI, I know people are saying it didn't end. I'm not saying it ended. Okay. I'm not saying it ended. I was just going with it to show you where that kind of goes if we continue with that analysis. All you really need to say is the FBI hired them to do the investigation and the defense paid them to travel over here and testify about it.
Communication between that time that rekindled this relationship. There are attorney requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Alessi, what you should do, what the court should do, is go with the federal government and ask
So
questions.
just to be clear, I am not having ex parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Reese.
It wasn't a request for that.
You suggest
But like, honestly, if you thought a lawyer lied, if you thought a lawyer was just dead bang lying and you're going to kick him off a case when a woman's life is, why not call him? Who cares? Like either lawyer would think the judge is going to do something nefarious, calling the federal government, the federal prosecutor's office. I agree it's unnecessary and you don't need to. But if you're going to call him a liar and say they knowingly misrepresented something, I'd probably make the call, which is also why I'm not a judge.
that I called.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is, it is not incumbent on the court to provide the proof that defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. No acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that Parker's position did not change, it did change. Their opinions did change by the time they reached trial. It's not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical. And that was hidden from.
Well, that was not a good point to bring up then by you. If you want to show bias, the fact that he said, I can talk about this, and then he did, doesn't show bias, in my opinion.
The court, the Commonwealth, and the jury. It is the
Payments show bias. I don't care how little they are. At least some jurors may think that's biased.
bias and the leaning towards one side that was not disclosed. The first trial was disclosed last week or 10 days ago. So let me offer a quick history. It is true.
So then he goes back, does the timeline again. Here he actually says, I did believe it was from the Fed. So let's hear that.
When I first spoke to the court, I believe the documents provided. Offer a quick history. It is true. When I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests.
So he did fully believe it. It was a mistake. He reads the timeline again. He misspoke, but it's not the source of the information he got. It's the substance. So he definitely tries to downplay exactly what happened that we all saw. And it was incredibly important, incredibly important. His misspeaking or inaccuracy was important. He says Yannetti has the responsibility for all the other attorneys that he signed off on because he's the only Massachusetts attorney. Keeps hammering ARCA should have been independent and they weren't. Then he goes to a transcript that was on June 5th, which was before the emails, and talks about that a little bit. This was before the information, the discoverable information even existed.
Whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial, day 26 of trial, June 5th, 2024, discussing scheduling and voir dire hearings, the defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this room knows why I can provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world.
And that was all true at the time, because that's on June 5th. If they have to pay this trial, can they say they hired them? What I think would happen, what I would do is say, We did not hire you to do this investigation. We didn't hire you to do an inspection. We didn't hire you to do any testing. We didn't hire you to do a report. Yet you did all that. Somebody else hired you to do all that, right? Then after your report was done, after your findings were made, after your conclusions and your expert opinions were formed, you sent them to both sides, right? You sent them to the Commonwealth, sent them to us. Either of us could have called you to testify. Is that right? We called you to testify, right? And we had to pay you to come testify, didn't we? How much did we have? That's how I would do it. I would add on, be like, and we were the only ones that called you. They didn't even call you and they could have. And we also had to pay you to show up because you're an expert, right? That's how I would do it. I would make it seem like unfair that we had to pay you, but we still did have to pay you. Commonwealth should have called you. The federal prosecutors are the ones that hired you. That's how I would do it. So yes, they do have to say that they paid them to come show up, but they did not hire them as an expert in the beginning of the case. They did not hire them to do any of the testing. They did not hire them to do the report, and none of that has changed. And they have to find a way to present that appropriately. All right, we're going to jump ahead a little bit here.
Page 71.
Okay.
Line 4. Importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked in the court, had you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARC are wholly independent from each other. This is also consistent with the representations regarding payment. There are questions voir dire in the trial about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain...
I'm glad he said that, right? I'm really glad he said that because some of his comments made it sound nefarious to prep these experts, but that's not the case. The point is you got to turn it over. You got to tell them you did prep and you got to give them the money that you paid him. And he's right.
Way that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice date of July 12, 2024. The rest to...
Hold on 1 second, please.
The defense case, Attorney Alessi takes today, this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense.
This is speculation. Somebody else said, why can the Commonwealth speculate and the defense can't? From my position, the defense said, I'm going to speculate. Anytime you do that, the judge is going to say no. If you just do it like Brennan, sometimes you can, but I agree. That's pure speculation. How does he know what everybody knew? How does he know what ARCA knew, what the defense knew, what the feds knew? He doesn't. He's making an argument here.
ARCA experts knew. Dr. Wolf knew. Dr. Rensler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representation that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, and they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson.
Also not true. If they thought they were going to get paid by the feds and the feds were like, no, the defense can pay you, they would still have been keeping their time.
And so the March 20th email asked...
It's late. I think I said keeping their time. Keeping their time. This needs to end soon. We're almost at 2 hours. It's too long for me.
...for an engagement letter and a retainer. And then the 24th saying you need to take a step back because of the U.S. Attorney's Office.
22nd.
I'm sorry, 22nd and 24th. There is obviously more communication because the relationship re-engages at least on or before May 1st, 2024. And these witnesses understand that they're going to be paid by the defense. And as I mentioned, in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised.
Lita said, so what does Brennan actually want? It's a good question because I don't think he ever says like kick Jackson off the case. He wants the court to do something with the violation of the rules of professional conduct in Massachusetts. That's what he wants the court to do. I think we all know without saying it, that means revoke the pro hoc vice admittance of Jackson and maybe reprimand Yannetti for signing on to allow him to practice in Massachusetts. Joss Girl Peter would love to see a poll in your chat. Who actually thinks she's guilty? We'll probably save that for another video on another night. The Middleman podcast, is all of this even worth it for D to get Arca on the stand? I mean, the jury didn't even believe them last trial. I think it is. I think it is the single most important piece of evidence, personally. As somebody who came in, didn't know a lot about the case, there was a lot of stuff going on and a lot of noise and a lot of arguments and yelling and, conspiracies and whatever and stuff that didn't really line up. That evidence lined up the most and made the most sense to me. And I don't want to reveal, I think it did matter. I think it did matter to people who mattered in this case. I'll just say that.
What they were paying witnesses apparently was the defense themselves. And then before that June 10th hearing, where the representations were made, there was a June 9, 2024 phone call. Another participated telephone call down. And then we see before the voir dire testimony, there is billing to the defense, which now we don't pay by the defense, prepared for voir dire testimony. June 17, 2024.
So he starts going through the actual invoice now, which is nice. We got so many facts and we learned so much in this hearing today. 6-9 was a phone call with Jackson. 6-17 prep for voir dire. 6-18 round trip. 6-21 testimony or trial testimony prep, et cetera, et cetera. And he's going to run through the whole thing so you can listen to it and hear exactly what it was for. It was absolutely for trial prep. Now, I don't know if they actually said, I'll have to listen again here. Did he actually say testifying? Because if he did, it's like, that is what it is. And also, they bring up Jackson talking to a reporter saying, I didn't pay him to testify. Oh, I would say that again. I don't pay them to testify. I pay them for their work on this case or something like that. Semantics and words, but plausible deniability.
What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or was this solely the preparation of Dr. Renshaw on his own? On the same day, 3 hours billed by Dr. Wolf prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Renshaw, and also separately for his testimony, 8 hours billed, 12 hours of Dr. Wolf billed to the defense. June 21st, Dr. Renshaw prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Renshaw on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer.
I love how they act like that engagement retainer email meant anything. Like that was over when they said pause. Josh H makes a great point. Why did ARCA keep track of their hours? Oh, because someone is paying for it. Who, they don't care. Lawyers keep track of their billable hours in pro bono cases. We just heard in an interview that Karen Reed's lawyers have $5 million worth of billable hours that they don't think anybody's ever going to pay for. Interesting, right? It's a good point in the timing. What else do we got? We're almost done. They keep basically saying we don't think we're ever going to have all the information. I don't understand why they can't just ask ARCA. Is there anything else? Do they think ARCA is going to lie? You can ask the federal contractors what they think under oath. Are they going to lie? I think they would say the same thing. Everything we said under oath at the time was true. They didn't pay us till after. I don't think ARCA is going to lie for Karen Reed. That's my opinion. I don't know, but that would be my opinion. He also said, I'm not trying to be overly critical of another attorney. I know they can laugh, but I've tried to be fair and I have no confidence in that I will receive anything from them. Then Alessi gets back up. They talk a little bit about, Jackson reporting or talking to the reporter. The actual quote is, did you pay them to testify in the first trial? No, of course not. Definitely didn't sound like, if you watch the interview of Jackson, definitely didn't sound like he was also thinking, no, I paid them for their work, not their testimony. But again, it's the argument he makes. You can do what you want with that. He asked Ms. Little if she remembered the March emails. She said no. Defense is not perfect in their compliance with Rule 14, but they are with the Rule 3.3 of professional conduct. Then, okay, the very end here, we're done. This is the last clip I'm going to play. I actually think this was potentially, the best point made by Hank Brennan. When he comes up here at the end and he reads this, let's listen to it here.
My arguments to the court have always been focused on Rule 14.
Which, again, to me, you don't throw a lawyer off the case for that. And I don't think the Rule 14 that there was any prejudice. So I think that's a losing argument, the Rule 14. But
The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in the pleading,
That was filed late, right? The
February
first Saturday or something.
February 16, 2025. This sums it up,
so 9 days ago, the defense filed this. 9 days ago, February 16th.
really. And this is signed by Attorney Jackson, Attorney Alessi, Attorney Manetti, certificate of service by Attorney
Was
Little.
it signed by Ms. Little? It's not,
Ms.
right?
Little has
It's
only done a
maybe
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alessi, and Manetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Daniel Wolf, PhD, and Andrew Rentler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense. It is not made in good faith. It is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know
That was on February 16th that they wrote they were not hired or paid for by the defense when you paid a $23,900 bill for trial prep testimony. I just don't get that one, right? I don't get that one. Is that just a mistake? Did they not know that they paid it? I just don't understand that. We didn't get to hear much context or explanation around it. That's the one that leaves it up in the air where I don't really know what Judge Cannone is going to do. Ashley said, final thoughts. What do you think is going to happen? I can't seem to bring myself to think that Judge Cannone is actually going to remove Alan Jacks from this case. There's no way you can push him to trial if you remove the lead trial counsel whose office has been handling everything. If you kick him off, pretty much have to kick Eliza Little off too. So then what are they going to do? The lawyer that's doing probably the most of the grinding for them and research and discovery and all that, and Eliza Little, and the lawyer that's doing the most arguing and handling of witnesses in trial, Alan Jackson, that's going to cause a major continuance, a major appellate issue. Why do that? Why create that issue? The defense is going to find another lawyer and they'll come up with, arguments, and they'll do maybe 90% as good of a job and whatever. But why do that? Talking about her comments of grave concern going viral, that would be incredibly viral. I just can't in my mind see that actually happening. Maybe I'm wrong, but I just can't see that happening. Maybe sanction him, maybe make him pay $2,500 or something like that. Maybe make him take a class. I don't know. But I would really be shocked. She would have to call him a liar, right? I don't believe you with the context of what you said you had in your head. I don't believe you that you meant X, Y, and Z when you actually said this. I don't know. To me, I just can't see it. I just can't see it. The most surprising thing for me is that Bev never seen the Federal Protective Order ARCA. Is that normal? If she doesn't need to see it, I understand some judges not wanting to get involved in that. I mean, I would have given it to her personally. I don't know. That is weird. All this stuff with the feds is always weird. It's always weird. I've never had a trial where the feds are involved in the state prosecution like this. Never. And I've definitely never had them where I, as a defense attorney, wanted to use the experts that the feds hired. So this is a truly one-of-one situation. Maybe not one-of-one. It's probably happened before, but I've never seen it. Karen Lisk. I've never experienced it, I should say. When ARCA writes their report, they didn't know anyone or the case, so how would it be possible for it to be biased? It's not that the report is biased. It's that they are now getting paid by the defense and working with the defense on their testimony. Does that make them biased? It is an argument to the jury. And the way the rules of evidence work is I can ask you, Karen, is this your husband you're here testifying for? You love your husband, right? You want him to win this case. Doesn't mean you're going to lie, but you definitely want to win this case, because I'm trying to say to the jury, she's biased for her husband. She's trying to help her husband. Doesn't mean you're going to lie, but that's the type of argument you can make. Peter, I got to attend an argument at the Supreme Court today. It was awesome and a dream come true. Law is endlessly interesting, and I'm grateful to be studying it and for your channel. Well, Coop, welcome aboard. Glad you're here. Glad you're studying it. Glad you are in the field and enjoying it. Okay, that's all I got. I got to run. I love you guys. Hit the like button. Even the ones that hate me, love you too. Glad you're here. Glad for the discussion. Just if you're a jerk and you think that that's going to like do something or like get under my skin or get under somebody's skin in the comments, it's a waste of time. Don't do it. Go find yourself, do something productive with your time, right? Like tell us your point and why you think that. That's something I would love to engage with. So I appreciate you guys so much. I hope your neighbors were kind with your backyard construction. Looks amazing, by the way. We have a great neighborhood. And some of the neighbors are going to love to come over and play as well. I'm playing early in the morning tomorrow. I got to get my beauty sleep and ready to pickle in the morning. You guys are the best. All right, I'm out of here. Please hit that like button. Please subscribe if you haven't already. This was a really interesting hearing to me. So I'm glad we could hang out and talk about it. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.